So let's finally, an hour in, take a look at how the EEOC might just have destroyed California's entire case. Here's the EEOC's actual response document. Plaintiff EEOC files this opposition in response to proposed intervenor Department of Fair Employment and Housing's ex parte application to shorten time. While the EEOC opposes the department's motion to intervene on the merits, that's what we just went through, the present intervention motion should also be disallowed because, as explained below, it arises from representation prohibited by the California Rules of Professional Conduct. Those are the rules, the ethical rules, that govern how a lawyer operates here in the state of California, but every state is going to have their own professional conduct rules. Specifically, two DFEH attorneys who play leadership roles within the organization previously served as EEOC redacted, who helped to direct the EEOC's investigation into Commissioner's Charge number 480-2018-05212 against Activision Blizzard, Inc. We should stop. The accusation here is that some of the folks who helped to direct the EEOC's own investigation left with whatever information, confidential sources, knowledge of strategy, anything else, went to work at the state of California's Department of Fair Employment and Housing, and then led or helped lead the Department of Fair Employment and Housing's investigation and litigation against Activision Blizzard. And if that doesn't sound horrible to you, chances are you haven't been through a legal ethics course. But just like we discussed earlier in this video, that represents a massive, massive conflict of interest. Let's continue. These same attorneys then proceeded to represent the department in connection with these intervention proceedings, which seek to oppose the consent decree that arose out of the very investigation they helped to direct while at the EEOC. Such representation is prohibited by the California Rule of Professional Conduct 111A2, and this conflict is imputed to all Department of Fair Employment Housing attorneys by virtue of California Rule of Professional Conduct 111B because of the department's failure to screen the individual attorneys. We're going to talk about that more in just a second. But suffice it to say, if you don't handle things right and you have this existing relationship and you go to a different government agency and they don't put up a firewall because you're not allowed to bring in information that you've gained in another capacity over to your new firm here at Department of Estate, if you don't put up that firewall, your entire firm is effectively tainted. And that might affect basically everything. After being informed of this conflict, the department retained new counsel, but appears to have filed the present intervention motion just hours after this counsel was retained, strongly suggesting that the motion is a product of the prohibited representation. So here we have a situation where the EEOC tried to tell California that this was an issue and told them in a couple of places, which we won't go over the specifics of. California denied that it was an issue until the EEOC basically refused to talk to them on a phone call that was called on this particular issue, whether or not they should intervene against the consent decree that the EEOC had filed with the court. After the EEOC presented strongly that they would not talk to these people on this score, they changed counsel to an outside counsel, but filed the intervention motion within hours of that change. So here the EEOC is effectively accusing the state of California not just of ethical breaches, which of course is the bulk of this document, but also of lying, of saying, you're saying that this intervention motion is not tainted by the involvement of these people, but that can't possibly be the case on the timeline presented. Like I said, the EEOC here is using its nuclear arsenal because even though they are directing this against specifically the intervention, the fact that the state of California is trying to intervene against the consent decree that the EEOC has entered into, there is no real reason that the arguments presented here by the EEOC couldn't apply to much, much more of what the department has put together against Activision Blizzard, depending on the timing in which these people went from the EEOC over to that department. Let's continue talking about it. First, we get the factual background, and these are referred to, for purposes of attorney-client privilege, as DFEH attorneys 1 and 2. When you see those designations, those are the people that went from the EEOC to the Department of Fair Employment and Housing, at least according to the EEOC. Now, you also see a lot of redacted bars. This isn't a CIA document all of a sudden, but EEOC, rightly, is concerned about attorney-client privilege. They're describing what these people advised them on, what they presumably advised the DFEH on, and all of that doesn't really belong in the public record. They do point out, however, that attorneys 1 and 2 engaged in active supervision of subordinate trial attorneys and had authority to direct and improve their work, and that attorney 2 was delegated key authority with respect to the Activision investigation in her role as a redacted. For example, redacted. So we can't actually evaluate these kinds of things, but we have no reason to believe that the EEOC would just straight up lie about what this individual's role was at the agency, and that creates a whole bunch of problems. Now, what are those problems? Well, it's not just impropriety, but it is the appearance of impropriety. As the EEOC says here, it is clear that the department's own attorneys, including attorneys 1 and 2, represented the department in connection with the intervention proceedings at least until October 5th, 2021. As discussed above, these attorneys authored a series of emails between September 29th, 2021 and October 1st, 2021 regarding the department's intent to intervene. In addition, these attorneys appeared for the Meet and Confer, the teleconference, on October 5th after being notified of the EEOC's objections, and Attorney 2 attempted to discuss the merits of the intervention motion, which the EEOC flatly refused to do until someone else got on the phone call. Now, why is this an issue? California's Rule of Professional Conduct 111, enacted on November 1st, 2018, is entitled Special Conflicts of Interest for Former and Current Government Officials and Employees. And I did, as I do here in Virtual Legality, I checked these all out for you, but the EEOC appears to describe them well, both on comments basis and in the language itself. What does 111A say? It says, except as the law may otherwise expressly permit, which is not really an issue here, a lawyer who has formally served as a public official or employee of the government. If you worked at the EEOC, then you're subject to various rules, and you shall not otherwise represent a client in connection with a matter in which you participated personally and substantially as a public official or employee, unless the government agency gives its informed written consent to the representation. So, you worked at the EEOC, you were bringing up a claim against Activision, you were bringing up a claim against somebody else, you moved to a different firm. Under the California rules, assuming you're practicing in California, you agree that you won't represent somebody in connection with a matter that you work for a different government agency on. It says Rule 111A2 provides an exception where the appropriate government agency gave informed written consent, but it is undisputed that there has been no such consent by the EEOC here. If all of this is as the EEOC describes, then the state of California has a real problem. Now, you might be wondering about that personally and substantially. That's what the EEOC then goes forward to try to establish. It says the term personal participation includes both direct participation and the supervision of a subordinate's participation. Here it is clear that the department attorneys 1 and 2 participated personally and substantially in, this. All redacted, but presumably the EEOC lays out a case there. And it says Rule 111 indicates that this sort of direct advice and guidance regarding the substantive merits and strategy of a case constitutes personal and substantial participation. Personal and substantial participation may occur when, for example, a lawyer participates through recommendation, investigation, or the rendering of advice in a particular manner. So you sit down across the desk from me and you ask me for my advice. That's my personal and substantial participation, even if you go against it. I've participated in the matter. And that raises all of these potential ethical issues. Second, the EEOC says, both attorneys also engaged in active supervision of subordinate trial attorneys and had authority to direct and approve their work. In sum, both attorneys participated directly and through active supervision in actions going to the heart of the merits of this matter. Further, California Professional Rule of Conduct 111B provides that when a lawyer is prohibited from representation under paragraph A, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in such a matter unless the prohibited lawyer is screened from any participation in the matter and is apportioned no part of the fee therefrom, and written notice is promptly given to the appropriate government agency to enable it to ascertain compliance with the provisions of this rule. So first of all, it's important to note that the use of the term firm in the California Rules of Professional Conduct in most other states will incorporate agencies, sub-agencies, municipalities within governments, because that's intended to control legal action in whatever these bodies might be. So here it says, okay, you've got somebody coming over from the EEOC. We don't really want to harm people's ability to go between employers. So they can go over, but they have to be screened. Why do they have to be screened? They have information. Whether or not that's strategy, whether or not that's just in their head, they have information that could be in conflict, that could be using their position with the other agency in a manner that is problematic. That's that image of impropriety, even if it's not intended. And if you screen them, you can still work as a firm here as the Department of Fair Employment and Housing. If you don't, you can't. And even if you do screen them, you have to go and give written notice to the EEOC so that they can follow your firewall process and make sure that your people are properly separated out from what would be a conflict of interest or potential actual disclosure violations. Here, says the EEOC, the department met neither the screening nor notice obligations. First, there is no claim that the department promptly provided written notice to the EEOC. Second, it is clear that the department failed to timely screen attorneys 1 and 2 from participation in these intervention proceedings as discussed above, and it's redacted here, but they did mention they were on phone calls, they were in email chains, and so there can be no claim that there was timely isolation of these lawyers from any participation in representing the department in connection with the intervention proceedings, as would be necessary to show that timely screening took place. Thus, all Department of Fair Employment housing attorneys were and should remain barred from representing the department in this matter. You put those two rules together, the EEOC says the department itself should be barred from representing the state of California in this matter. And if you look at this and you say, well, okay, that's focused on the intervention proceedings, but if this is an issue, when did it happen? If it happened before this intervention just occurred, which it would seem likely is the case, then how much were they touching the department's actual action against Activision Blizzard? Because if they were strategizing with information that they got from the EEOC, just if they were present and it looked like they could have been, there are major issues with the department and the state of California. Then the EEOC tells the courts what they think it should do. This says federal courts have inherent powers to manage their own proceedings, including the ability to craft appropriate remedies for violations of ethical rules. DFEH's intervention motion is the product of prohibited representation. Even assuming that the department retained present counsel at 8:52 a.m. on October 6th, it beggars belief to conclude that present counsel could have authored the intervention motion in the 11 hours that elapsed before filing without relying on the work product of the California attorneys. The DFEH attorneys should be barred from providing work product or advising present counsel regarding the intervention. Case law recognizes the propriety of barring these attorneys from providing work product to or engaging in further consultation with successor counsel in certain circumstances. In applying the pertinent tests, courts have looked to the extent to which the prior and subsequent representation were factually related and the relevance of the general and specific knowledge gained through prior representation to the subsequent representation. And they also offer, the EEOC says, look, if current counsel for the department disputes that the intervention motion constitutes the work product of DFEH attorneys, we're amenable to counsel filing a declaration under penalty of perjury detailing the steps they took to prepare the motion and the extent to which they did or did not consult with or rely on work prepared by department attorneys. Sure, you go right ahead and file a document. We'll check it out, which I think the EEOC feels pretty confident they're going to be unwilling to do. Here, they continue, the general and specific knowledge that the department attorneys 1 and 2 gained in their prior representation of the EEOC is highly relevant and closely factually related to their subsequent representation of the department. Indeed, they are seeking to oppose the very consent decree that arose from the investigation they helped to direct while at the EEOC. Here, as in precedent, DFEH attorneys 1 and 2 gained information about the merits of the EEOC's legal theories and other confidential information about the Activision investigation during their prior representation. These circumstances plainly demonstrate at least a reasonable possibility of confidential information being used in the formation of or being passed to substitute counsel through the work product of the DFEH attorneys, and the need for a robust protective remedy is especially great given the unique circumstances of this case where 2 former EEOC attorneys intimately involved in investigating charges against Activision while at the EEOC now seek to oppose the consent decree that is the culmination of that very investigation. While Rule 111A's prohibition on representation applies regardless of whether the lawyer in question is adverse to a former client, the concerns animating the rule are at their zenith, where the interests are directly opposed. And I highlighted this not because they're wrong or anything of the sort. EEOC is correct here to say, hey, this is bad, period. But it's worse, it's at its zenith when you're actually opposing the client that you used to provide services to. That you've violated the code of professional conduct, you've taken whatever information you've had, you've got issues with impropriety, conflicts of interest, non-disclosure, whatever it might be, attorney-client privilege, and then you go and oppose what you were working on before. This is the very height of a tainted attorney and law firm. But note, while Rule 111A's prohibition on representation applies regardless, applies to what the department did against Activision separate from the EEOC. And that might not sound fair to you, and in fact, it probably wouldn't be. But ethics rules are important, and it would appear, if this is as described by the EEOC, that the state of California was playing fast and loose with this stuff. If you think it's odd, if you think these are really technical or weird requirements, I can tell you, I've worked at big law firms for a long, long time, and virtually every week, but at least every month, you get screening emails. You get, hey, Bob or Mary or Susan, they're coming over from a different firm. They're coming over from the state government of Michigan, wherever it might be. You need to screen them from the following matters. These are the things they worked on when they were in that particular role. They cannot be a party to conversations or document sharing or anything else related to these matters, because these ethical rules, these conflict of interest rules are so important to the practice of law. This is not some technical foot fault in the back pages of a legal encyclopedia from the 1600s. This is the bare minimum essence of ethical representation, and the EEOC is calling the state of California out and realistically doesn't care that this could blow up the entirety of the representation and litigation against Activision Blizzard. In fact, I would expect Activision Blizzard to bring this up in their response document, and that's a big problem for the state of California. Why is this so important, in particular with respect to government employees? It says courts have articulated special concerns in the context of potential violations by government attorneys for the following reasons. First, because government attorneys may have had access to more kinds of information in connection with the prior representation than private attorneys typically do. There is a greater potential for misuse of information, including information that is not necessarily confidential in nature. Second, the public is generally more concerned about government improprieties than about private improprieties. Thus, the appearance problem is more severe because the public is likely to be more critical of this potential misuse of information. For all these reasons, the appropriate remedy requested by the EEOC to address the violation of Rule 111 in this case is to disallow the department's intervention motion and bar the department's counsel from providing further work product or advice to its new outside counsel. If the court is inclined to accept the motion for intervention, if it doesn't believe anything that we just said, we respectively submit that opposition to the motion that we discussed before we looked at this document. This is an absolute bombshell kind of document from the EEOC, absolutely laying waste to the state of California. Primarily, I would argue, obviously speculative, because of the way the state of California handled their work sharing agreement, handled bringing harassment claims, ignored their settlement negotiations, brought them up to journalistic outlets as problematic, allowed for the EEOC to be raked over the coals on this amount of money that both sides knew was reasonable for what the EEOC statutory requirements and general settlement disposition were. And now you see the full breadth and power of an angry federal organization. The EEOC is taking no prisoners on this. And my guess is the state of California wishes that they hadn't done it in exactly this way.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.